WFTL.
About the law and the law one. About the law and the...
Are you ready for some free legal advice? We can hear the roosters, but it's never too early to know your rights. Feel free to call into the show in the next 25 minutes with questions of your own. Just dial 877-850-8585. Without further ado, here is the host of Vastola on the Law, Attorney Jeff Vastola.
Here I am, and good morning, everybody. Thank you so much for tuning in. This is Vastola on the Law, and I am Jeff Vastola. I'm an attorney. I've been an attorney in Florida for over 23 years now, I believe, and my practice day-to-day is that of a trial lawyer. I spend a lot of my time in the courthouse. This week, as a matter of fact, I spent 4 out of 5 days going down to the West Palm Beach courthouse every day for hearings, which was unusual. I don't typically go to hearings that frequently, but anyway, I am here to give you free legal advice. All you have to do if you're a passive listener is to sit back and enjoy the show. I'm going to be talking about different forms of bankruptcy today, and there's a reason why. I'll explain that in a moment. But more importantly, if you want to be an active listener, you might ask yourself, well, what's an active listener? An active listener is somebody that has a question of their own. And that person says, I'm going to call Jeff and I'm going to get some free legal advice because that's the purpose of the show. Please do that. I give priority to people that call into the show. The number to do that is 877-850-8585. And I will answer your question right here, right now, if I can. If I cannot answer the question, then I will do the research that I have to do to give you an educated response the following week. So you can either tune in the following week to get the answer to your question, or if you're unavailable, you can't make it, or if you've simply slept in, then you can go to my show page on the 850 WFTL website, and all of my shows are uploaded into a library via date and title, and I think we probably have to update maybe the last 4 or 5 of them, but you can typically find your show based on the date that you know that you called in. Then you would go to the next week's show to listen to the answer. And of course, you can always contact me to say, hey, Jeff, I'm so sorry I missed your show. What's the answer to my question? And if it's a simple one, we can certainly spend a couple of minutes on the phone. So that's how the show is done. As you heard in the introduction, this show is sponsored by my law firm, which is Vastola Legal. And I have 2 offices, one in Stewart, one in Palm Beach Gardens. But I like to emphasize the fact that we represent clients throughout the state of Florida. I'm licensed throughout the entire state, and as a result, and especially because of the nature of what I do, one of my areas of practice is medical malpractice, and typically that takes me all around the state to handle those cases. So if you know of anybody that you think, first of all, might want some free legal advice, anybody can hear this show, even though the radio waves, if you tune into a radio, are only going to take you from Fort Lauderdale to Vero Beach with 850 WFTL. You can listen online. You could be in California. Now, of course, you'd have to wake up pretty early to listen to this, but you could be in California, go to your website, at WFTL website, and you can listen live. So you can tell anybody who lives in the state of Florida that wants free legal advice to call in. I don't give advice outside the state of Florida. That was an agreement that I made with the Florida Bar many, many, many years ago when I first started doing radio. I got the Florida Bar's approval to do it. And they said, well, as long as you're not going to give advice in states where you don't have a license, we don't have a problem with it. So there you have it. As I mentioned, I have 2 brick and mortar offices. If you'd like to see me to talk about a case that you think you may have, then feel free to call and make an appointment, and I would enjoy the opportunity to sit with you. I also have a website. If you'd first want to find out a little bit more about me before you jump into the deep end, you can go to vastolalegal.com. That's V as in Victor, ASTOLA, legal.com. And you can also contact us via the website. That inquiry form goes directly to my email inbox. So one other thing I want to mention, a little bit of self-promotion, and this applies across the board, 24/7, weekends, nights, whatever. I have a toll-free number that I like everybody to know about because I want you to use it. It's 833-VASTOLA. That's 833-827-8255. 8652. If you're in a situation where you need some immediate advice, legal advice, use that number. That number is forwarded to my cell phone 24/7, and I answer it. If I'm not able to answer it for whatever reason, leave me a voicemail message, and I will call you back. So that's it for the self-promotion. I want to talk about bankruptcy today. I don't really want to talk about bankruptcy today, but I'm going to talk about bankruptcy today because of something that happened during my work week. And that's typically how I come up with a topic, unless somebody has called in the week before with a question that I had to research. When that happens, that question typically ends up being at least one of my topics for the day. But we have not had that happen in quite a while. We've had some callers lately, but it's been about things that I knew enough about that I didn't have to research. But I'll tell you what happened. If you weren't already aware, it's public knowledge. Borden Dairy filed for bankruptcy last week, Sunday, about 6 days ago. And regrettably, one of my cases is against Borden Dairy. I have a car accident case where a driver of a Borden Dairy truck ran into the back of several vehicles, actually, and one of them was my client. And we've been in litigation for probably well over a year now, and we are in active negotiations to get the claim resolved. And we were literally, I'm not kidding, literally about $5,000 apart in settling this six-figure case. And all we were doing was waiting to hear back from the defense attorney. I had sent an email on Friday saying, okay, this is where my client has allowed me to move to negotiate, and we were so close. And I was simply waiting on Monday morning to get some kind of verification. And the response I got was on the Monday of this week, I'm very sorry, Jeff, but my client filed bankruptcy on Sunday. Boy, you talk about the wind coming out of your sails. So, first of all, I'm not exactly sure how they filed a bankruptcy on a Sunday, because I didn't know that the courts were open on a Sunday, but we electronically file, at least in the state of Florida and federally, we electronically file all of our documents. So yeah, the courthouse no longer has to have an open door for somebody to walk in and walk up to the clerk's desk and say, here's my lawsuit that I want to file. When I started as a lawyer, and for several years after that, that's the way you did it. If you wanted to file something, you either mailed it to the courthouse if it was not important, or if it was important, you walked down to the courthouse or drove and walked into the courthouse and went up to the third floor or whatever floor it was on, walked to the clerk's desk and said, I need to file this today, and literally handed paper. That's the olden days. Now, the newen, I just made up a word, the newen days. Electronic filing has taken over, and I suppose what Borden Dairy did was they filed their bankruptcy on Sunday, but it probably was formalized on Monday morning, I would suspect, unless the court accepted a filing on a Sunday, who knows. But anyway, I digress. Borden Dairy's bankruptcy imposed what's called an automatic stay, not just on my case, but every bit of litigation involving Borden Dairy across the United States and perhaps even internationally, I don't know. But what that means, an automatic stay, is you can't do anything in your case. You can't even attempt to settle your case anymore, because Borden Dairy is going to hand over the reins of its finances, at least temporarily, because of the type of bankruptcy that it filed, to a trustee. A trustee would be designated by the bankruptcy court. That trustee would be somebody knowledgeable, and it might even be more than one trustee given the size of the company, Borden Dairy. But the trustee will make decisions about reorganizing, still early, the company's financials. And so we sit and we wait and we hope that as part of this reorganization process, our claim does not get flushed down the toilet, because that might happen. And that could certainly happen in the event that your claim was against an individual who filed probably what most people consider a bankruptcy to be, which is a Chapter 7, which is a liquidation type of bankruptcy, where you're simply telling the court, please discharge all of my debt, pay what you can with what I have, and then when you wrung every drop of water out of the rag and there's no more money, then discharge everything so that I don't owe any to anybody else. That's a layperson's description of a Chapter 7. Keep in mind that there are some types of debt that cannot be extinguished in a Chapter 7. Punitive damage awards, for example, cannot be discharged. And it used to be, when I graduated from law school with a mountain of law school debt, it used to be the law that you could not discharge your law school loans through bankruptcy, which was a smart move on the government's part, because I think a lot of people would have filed bankruptcy back in those days. I know I would have been close just to discharge those debts. There was my debt was 6 figures after I graduated from law school alone. That wasn't even college. So anyway, let's get into it. But before I get much further into the description of the 6 different types of bankruptcy, I want to remind you that your phone calls are my priority. I want your legal issues to take precedence over what I'm talking about here today. So call into the show. Elliot is here with us this morning. He's the board operator. He'll take your phone call. He'll put you live on the air with me. The number to call in is 877-850-8585. I'm going to give you that number once again, just in case you were trying to write it down. The number to call into the radio station is 877-850-8585. All right, so call me anytime. Don't wait for me to take a breath and say, oh, this is a good time to call, because if you call at 7:55, probably not enough time for us. Even a simple question typically takes at least 5 or 10 minutes, and they cut me off at 7:58, just so you know. So although it's billed as 30 minutes of free legal advice, I actually only get about 27 minutes, but that's okay. So bankruptcy, 6 different types. Let me just go through them very quickly, and then I'll go back and spend a little bit more time on each one of them. So you've got Chapter 7, which is an individual liquidation. Chapter 13, which is a repayment plan for an individual. You've got Chapter 11, which is a large reorganization plan. Now, some people think that 11 is for companies and 13 is for individuals. It's not necessarily true. A Chapter 11 can be used by an individual, but it would be for a very high net worth individual. So not everybody's going to qualify for an 11. That's why it's called the large reorganization. Chapter 12 is for family farmers and fishermen. You've got Chapter 15, which is applicable for foreign applicants. And I'm not exactly sure how that works, to be frank. And then Chapter 9 is for the municipalities. You may remember a long time ago when California or one of its major cities had filed for bankruptcy. They probably did that through a Chapter 9. So anyway, let's talk about each one of them individually. And of course, if you have any questions about these bankruptcy issues, I'm not a bankruptcy lawyer. I just decided to talk about this today because of what happened during my work week. I can either do the research and try to come up with a pretty good answer for you, or if you truly are a candidate for a bankruptcy and you just want to know who I might recommend, then feel free to call me and I'll be happy to let you know. So the number to call into the show again is 877-850-8585. And a plug for UM insurance. If you don't have UM on your automobile coverage, get it. If you don't know what I'm talking about, that's a good reason to call me, and I'll talk about it. Chapter 7 bankruptcy. It's what most people consider to be bankruptcy, quote unquote, I think, if you're a layperson. This is used for individuals, and it's liquidation, as I just mentioned. It's telling the court, I have a mountain of debt, and I've got a little trickle of income, and it's never going to match up, so I need help. By the way, bankruptcy is a federal right. This is not a state remedy. So bankruptcy is a federal law. It applies equally in all 50 states, and it is a right. It's a right for somebody if they qualify. Now, that's the catch. If you want to utilize bankruptcy as a remedy, you have to qualify. You can't say to a court, I really just don't want to pay this guy. I've got plenty of money to do it, but this guy really rubbed me the wrong way, and I don't want to pay him, and he's sued me, and I don't want a judgment against me. I want to discharge this debt so that I don't have to pay him. Well, when the trustee looks at your finances and says, whoa, wait a minute, you got plenty of money here. You don't qualify for bankruptcy. I'm sorry, this is not a remedy for you. Bankruptcy is only a remedy for those people that have, in its simplest terms, more debt than they have assets, and therefore you can discharge debt, at least specifically in a 7, the one that I'm talking about right now. And the remedy that you're looking for is the discharge of all debt. Now, I've had instances where individuals have filed a Chapter 7, because they're looking for a discharge of all of their debts, but they've been dishonest with the bankruptcy court, and they did not get a discharge. They didn't get the relief they wanted. They got a dismissal of their case. And this is a true story. I had a client who, this goes back a long time ago, who had a personal injury claim. And while his claim was pending, he filed a bankruptcy, unbeknownst to me and the lawyers in my firm. He went out and found a bankruptcy lawyer to file his bankruptcy. And in his bankruptcy application, he had stated all kinds of things that he represented through his bankruptcy lawyer were accurate. And then, see, what he didn't realize is that the left hand was going to talk to the right hand at some point. He thought that his civil personal injury lawsuit would be kept completely isolated from his bankruptcy lawsuit. And when his worlds collided, the you-know-what hit the fan, because it became obviously apparent that he was dishonest in his bankruptcy application. Now, his bankruptcy had been going through the motions for some time, but ultimately those two cases collided, and we had all kinds of email thread documentation and everything else that we were able to use, because there were allegations that the lawyers in my firm, because this was back when I had other lawyers that were working for me, that were working on this file specifically, had done things and had said things that were incorrect and caused him to do things that were incorrect and immoral and all this other stuff. But the guy apparently forgot or didn't realize that we had this email thread of communication that was like a mile long. And although he tried to throw us under the bus with the bankruptcy court, we obviously defended against those allegations, not in a formal lawsuit, but in communications with the bankruptcy trustee. And the remedy that he was seeking of a discharge of all of his debt flew out the window, and his case was dismissed. And the last I heard, I know that the bankruptcy trustee was making a lot of noise with his bankruptcy lawyer about sanctions, because when he filed his application, he made what the trustee thought were knowingly false representations of his situation. And you can't do that, especially in federal court. I mean, in court, no matter where you are, but you don't want to mess with federal court. The federal court's no joke. So, and not to suggest that state court is a joke. It's not. But I'm just saying that the standards are just a tad higher in federal court for the no-nonsense standard. Let me put it to you that way. The no-nonsense standard is much higher in federal court. So while I'm on this topic, I think it bears mentioning that if you have a pending lawsuit of a civil nature, if you have any kind of a claim where you are trying to collect money for an injury, a breach of contract, whatever it is, if you're involved in civil litigation and your remedy is the collection of money, please make sure that you talk to your lawyer before you go file a bankruptcy, because that's happened to me on a couple of occasions. And what happens is, when the plaintiff files a bankruptcy, when the plaintiff is involved in other civil litigation, the bankruptcy no longer belongs to the plaintiff. When you file, especially a 7, if you file a Chapter 7 bankruptcy, then you hand over all of your financials to a trustee. The trustee basically takes over all of your finances, including takes over all your assets, okay, except for those things that are accepted. I think you can keep your home, you can keep a car, and you can keep a very small amount of money or something like that. But your lawsuit is an asset, and the trustee takes over the asset. And ultimately, any money that's garnered from your case is going to go to the trustee to pay off your debt. And a lot of people, a lot of lay people that are involved in litigation don't know that. You know, and for a long time, even as a lawyer, until it happened to me the very first time, I didn't know it. And I had to be educated by the bankruptcy trustee that stepped in for my client to say, hey, by the way, this case is no longer your client's case. And so much so, by the way, that you have to execute a new contract. The trustee is going to go hire whatever lawyer the trustee wants to hire for that personal injury case. Now, I can't speak for other lawyers out there, but every time it's happened to me, and it's happened probably, I think, 3 times in my career, that a client has filed a bankruptcy without telling me, the trustee has hired me to further the case and ultimately resolve the case. So I think most commonly that's what happens, but it is a brand new contract. It's a contract between the trustee and the lawyer, which takes the place of the contract of the original client and the lawyer. And what that does is it removes the client from the case. I mean, other than being the named plaintiff, because the trustee doesn't step in as the plaintiff. The trustee is just pulling the strings. So anyway, again, I went off on a tangent about Chapter 7. I just want people to be aware of how it might affect you if you're planning to file a Chapter 7, especially if you have ongoing litigation. Please make sure that you talk to your lawyer. And if the lawyer that you have isn't aware of how it might affect a civil case that you have pending, then make sure to tell the bankruptcy lawyer that you're using to say, hey, by the way, I have a case. Because the bankruptcy lawyers are the ones that are really supposed to ask you the right questions, and they're supposed to know, and they're supposed to list any potential case that you have where you're looking for money as a remedy. That's an asset, and that needs to be listed in your bankruptcy application. And the story that I was giving you just a few minutes ago about that client of mine that got himself in trouble with a bankruptcy, he didn't list his case. That's what happened. He didn't list it as an asset, and the bankruptcy court found out about it later on. He tried to blame us by saying that we told him not to list it as an asset, which was total nonsense. So anyway, Chapter 7, keep in mind if you're going to file this, because you want to get rid of a punitive damage judgment. If you were driving drunk and hurt or, God forbid, killed somebody, the judgment that may have been rendered against you is most likely a punitive damage judgment, or at least a part of the judgment would be a punitive damage judgment. And you cannot have those discharged in bankruptcy. Those are going to follow you for the rest of your life unless you can pay it off. And they earn interest, by the way. And also, at least when I was a graduate of law school, you could not discharge your law school loans, but I think something happened. I might look into that. If anybody's interested, you can tell me to do that. But I think that changed, because I think somewhere along the way there was a lot of law school and perhaps even undergraduate college debt that was discharged. So I don't know much more about that. Now, so going in line, Chapter 9 is the municipalities. That's the bankruptcy that would be used by towns, cities, even school districts to reorganize and pay back what they owe. So it's a reorganization option for the government, essentially, is Chapter 9. Chapter 11, okay, this is what Board and Dairy filed on Sunday, which brought my case to a screeching halt. This is where large organizations, or as I mentioned just a moment ago, high net worth individuals can file for reorganization of their business, and specifically their assets, their financials. So they hand over the reins to the trustee. There's a lot of cooperation among the creditors when you go into reorganization. And I suppose they need that to reorganize, because the creditors may have to approve the plan. So we'll see. We will ultimately be provided what's called a statement of claim to fill out. And I'll fill that out on behalf of my client to say, this is my client's name, this is the nature of the claim, this is the value of the claim as we see it, and you make sure that it gets filed and served properly, and once that's received by the trustee, you are now a valid creditor of the bankruptcy filer. So my client will be a creditor of Board and Dairy, and we will be included in all of these communications about how they're going to reorganize and everything else. And who knows what kind of a say we're going to have, but I'm hopeful that ultimately we will still make some form of a recovery. If anybody is interested in calling in with a question, a comment, The number to call in is 877-850-8585. That's the number to call into the station. I'm actually almost out of time. I can't believe it. Yep. So let me wrap up with some self-promotion real quick. If you have questions about the other forms of bankruptcy, you can always call me or email me or whatever you want. If you have a case that's been turned down, I encourage you to call me, because there have been situations where I've taken cases that have been turned down and I have recovered for individuals. So if you'd like to talk to me about that, 833-VASTOLA is the number for you to call. That's 833-827-8652. If you have an injury, unfortunately, if any kind of a wrongful death claim that you'd like to talk to me about, then please use that same number. I'm always happy to call or receive your call and talk about things. And, of course, I don't send a bill for that. If you'd like to find out more about us, you can go to our website at vastolalegal.com. I have an associate that works for me. His name is Joe Grosjean. He's doing a lot of wills and estate planning type of stuff, which is completely beyond me, so I don't do that. But if you need a will, call Joe up in the Stewart office. That number is 772-419-0999. He can write a will for the entire state of Florida. You don't have to be a Treasure Coast resident to do that. But anyway, thank you so much for tuning in. Thank you so much for listening. If you need me, you know how to find me. And I hope that you have a great week. Talk to you next Saturday here on Vastola on the Law.
You've been listening to Vastola on the Law with attorney Jeff Vastola. Turn in next week for more legal advice and answers to your specific questions. You can call Jeff on his cell phone after the show by dialing 833-VASTOLA. That's 833-827-8652.